May it please the court. A free and functional press is a critical element of our democracy. As my co-counsel referenced in her opening statement, it is the only profession specifically protected by the United States Constitution. The free press was important in 1789, but it is even more important today. Today, the court must find that plaintiff's claim for defamation fails for at least two reasons. First, plaintiff failed to establish through clear and convincing evidence that CAT News and Andy Rather's statements were made with actual malice. Second, plaintiff failed to prove by a preponderance of the evidence that these statements resulted in Governor Justice's loss in the election. Under New York Times versus Sullivan, Pat Justice, as a public official, must prove that these statements were made with actual malice. That is, knowledge that the statements were false or with reckless disregard of whether they were false. But Carter testified that she had no idea the statements were false and had no prior reason to distrust Rather. Additionally, defendants' endorsements of political candidates during an election season do not rise to the level of clear and convincing evidence when proving actual malice. The Louisiana Supreme Court in Saint Ursula versus Thompson held that failure to investigate does not in and of itself establish bad faith. Plaintiff will claim that Carter's failure to investigate the claims fully suggests actual malice, but they do not. Plaintiffs have failed to call an expert to show causation, and instead have used only plaintiff's self-serving testimony. That is not nearly enough to meet their burden of proof through a preponderance of the evidence. Defendants, however, called Reese Murphy, an expert in political analysis, who testified that the statements made were not the proximate cause for Governor Justice's loss in the election. Even if the court finds that plaintiff has met its burden of proof, it still must rule in favor of the defense because of the affirmative defense we have established. Article 1, Section 11 of the Ohio Constitution provides that, in regards to freedom of speech and of the press, that every citizen may freely speak, write, and publish his sentiments on all subjects. Because the statements made were opinions, they cannot serve as the basis for finding liability in a defamation claim. When determining if the statements made were opinions, the court must apply the totality of the circumstances test set forth in Fuchs versus Scripps Howard and weigh its four factors. First, the specific language used. Second, the verifiability of the statement. Third, the general context of the statement. And fourth, the broader context of the statement. Application of this test is fluid, and the weight given to any one factor will vary based on the circumstances of each case. Today, the most important factor is by far the specific language used. The Scott test, used in Fuchs versus Scripps Howard and initially established by Scott versus News Herald, held that statements such as, in my opinion, or I think, are highly suggestive of opinion. Harris admitted that CAT News used similarly ambiguous phrases in the reports, such as gut feeling, suspicious circumstances, and journalistic instinct, that gave off an air of hyperbole and subjectivity and elicited an emotional response from the reader. Harris also admitted that Rather's first and third tweets posed questions rather than offering answers, which attempted to provoke thought among the reader, which according to Sikora versus Plain Dealer signals a writer's judgment and opinion. Additionally, the other three factors in the totality of the circumstances test, the verifiability of the statement, and the general and broader context in which it was made, all weigh in favor of finding that these statements were of opinion. Because we have established today, by a preponderance of the evidence, that defendant's statements were ones of opinion, they cannot serve as the basis for finding liability in a defamation claim. Your Honors, we could not have a truly fair and democratic election in the United States without the free press. They serve as a check on the government and a necessary resource for the public. Governor Justice cannot accept her loss in the gubernatorial election and seeks to blame her failure on defendants. But the law protects against certain false statements of the press to ensure their survival. Our liberty depends on the freedom of the press, and that cannot be limited without being lost. We ask that the court find defendants not liable for defamation. Thank you.